Hi there and welcome to part 3 of my deep dive into the judge's summing up at the end of Miss Letby's original trial. As stated at the end of part 2, today I'm going to pick things up on Tuesday, July 4th. Before doing so though, I want to briefly return to something I dealt with last time, to draw something out of the information given, which I feel increases clarity on what was going on. The handling of what was the totality of defense witness testimony in the summing up. As stated a number of times, the total amount of time James Goss spent on his summing up was almost 5.5 days. The amount of words he spent in that time reminding jurors of defense witness testimony was 62. Highlight 62 words in a document and time yourself reading them. 30 seconds? Don't get things twisted with the explanation. Well, he was only the one defense witness called. If we approach the question from the only morally defensible perspective, that of giving the witness testimony of the two sides a similar amount of airtime, being the only witness implies an increase in the summing up time to whatever Lorenzo Mansuti actually had to say. This is a point I overlooked, but additionally I would ask those of you still on the fence on the question of whether this judge was blatantly biased and therefore corrupt, to plug into your rational faculties the fact of only 30 seconds being spent on defense witness testimony in 5.5 days of summing up, then see what comes out the other end. And corruption is corruption, whether driven by inducements, fear, or simple personal malevolence. All arise from moral depravity. Moving on to what he said the next day, I was left needing to remind myself that I was reading the summing up by a judge in an English court by a portion of what he had to say about the Child D case. I quote, "Child D's mother recalled an event when she arrived on the unit and Letby was hovering around Child D, not doing much, holding a clipboard. She asked if everything was okay. Letby replied, everything was fine. The mother said she just stuck around. The mother said Letby was told to go away or words to that effect." End quote. This is the judge's summing up, the place where he distills the essence of material evidence. This is the state of destitution that the concept of evidence was reduced to in order to make possible the conviction of Miss Letby. Furthermore, it turns out that the father had no recollection of the event. I quote, "Child D's father did not recall this event. He recalled he was given a Father's Day card on June 21st by the staff. He said nurses were friendly and warm, and he was made to feel welcome when he went to the unit." End quote. So why remind jurors of the event then, giving it weight? Being uncorroborated by the only person with the same level of emotional investment, the father, was the gold standard in terms of evidence that the mother's recollection was not to be relied upon. It is pretty obvious that it was not shared with the father at the time. Had it been, his own evidence would have been more along the lines of, "Yes, I remember my wife/partner saying that to me." The alleged recollection is trivial, malicious, says nothing, and is in all likelihood a false memory, but the judge seems to have put it out there to simply pollute the minds of the jurors. 15 minutes later, in his summing up, it transpires that Miss Letby was designated nurse of not one, but 2 other babies in the relevant room. Nursery 1, the place with the sickest, highest dependency babies who are all supposed to have one-to-one nursing. Independently of the veracity or otherwise of Child D's mother's recollection, Miss Letby would have been risking the lives of those two babies every time she left the room. She had every reason to be there. The judge finishes off his summing up on Child D by reminding the jurors that when interviewed by police over 3 years after the events, Miss Letby had said she couldn't remember doing the Facebook searches done 3 days after the baby's death. Couldn't remember why she had remarked that the child looked like having overwhelming sepsis, something the suppressed high risk even Pseudomonas report of 20th May 2015 would suggest was almost certainly the reality, and also could not recall why she had made the observation to another nurse that about there being an element of fate in relation to the babies in their care. To include such nonsense in his summing up could have no purpose other than to put a question mark against the honesty of those responses. Just take a step back and look at the three pieces of evidence he is relying on to insinuate evasiveness on her part. That, as a compulsive Facebook information grazer, who clocked several thousand people searches over the indictment period, and almost certainly did such searches every day, she did not have a fixed recall of some done on one particular day over 3 years earlier, and then that, while obviously not denying having made the two utterances, was unable, after the elapsed time, to recall the chain of thought that had prompted the utterances. The judge next, somehow deeming it evidentially significant, reminds jurors that on the stand, fully 8 years after the event, Miss Letby gave evidence that she didn't really remember the night shift. He then went on to detail that this included her apparently being called to nursery 1 at 1:25 a.m., a desaturation event at 3 a.m., and the collapse event 45 minutes later. Were these events not covered by the statement that she didn't have a clear recollection of the shift? What can be the purpose of highlighting them except to simultaneously associate her with them in the jurors' minds and suggest she is seeking to distance herself from them for some reason? As I said, these are his last words on Child D. He then moves on to the twins, E and F, beginning with Child E. As in the preceding case, the identical play of an after-the-fact claim of suspicious behavior by the mother is a feature of his summing up. The remainder of it, a total of some 90 minutes, was a very extended summary of medical testimony, giving evidence of events we now, of course, know were wholly fictitious where Bohin and the two minion experts, Arthurs and Kinsey, are concerned, and imaginary where Doctors Harkness and Thomas from the Countess are concerned. Buried and entirely unexplored in the middle of all of it is even a mention that Miss Letby had submitted a Datix report on Child E because she felt the medical team, the doctors, had been late making the decision to go with a necessary blood transfusion. The difference of opinion over the timing of a blood transfusion to your intended victim is really the thing that is going to be the focus of your attention in the hours in which you are actively executing your murder, isn't it? I wonder where that counterintuitive and contradictory nugget of information went in the minds of the 10 jurors as they raised their hands to condemn Miss Letby for murdering that child. The other aspect of his Child E summing up worth remarking on is a piece of insight it provides as to the lengths this judge is prepared to go to in his grooming and conditioning of the jurors. Reading him telling the jurors there were significant conflicts between Miss Letby's evidence and that of the parents was news to me, and sent me combing through the summing up to find these conflicts. The almost red-handed claim can hardly be described as a conflict, as there is no dispute about the facts, just the construction the mother puts on them years later when Cheshire Police came knocking with an alternate version of reality. The only thing I found was that Miss Letby's recollection was that after the death, the parents had bathed the child, and their recollection being that she did it for them. Conflict? I'm not convinced. Significant? Please. At that point, it occurred to me that Goss is practicing a novel deceit where he pretends to still be correctly mining the evidence heard during the trial for the content of the summing up, while in reality he's smuggling into the summing up synthesized points which even cursory review will show to be wholly unsupportable by the evidence actually heard during the trial. He's like a gold miner looking to sell on a worthless claim to his dupe by dropping a few grains of gold, a few flakes of gold from his pocket on the ground and pretending to find them. In his summing up on Child D's twin, Child F, the first insulin case, a clinical event which Dr. Shu Lee spent long minutes highlighting as essential to the duration of the hypoglycemic episode, is covered as follows, I quote, "At 10:30, a new long line was to be inserted in Child F, as instructed by Dr. Saladi, with the removal of the old one," end quote. As explained by Dr. Shu Lee, the reason this line had to be replaced was that the dextrose it was supposed to have been delivering to the baby's bloodstream had instead been flowing into his groin and right leg for hours. So, while Miss Letby's inability to demonstrate perfect recall of events 8 years before, in her case in another life, and plainly unreliable and malicious false memory insinuations of harm and intent to harm are considered important things to tell the jurors to factor into their deliberations, the fact that for hours the child had not been receiving the dextrose necessary to raise its blood sugar is not regarded as something jurors need to consider in deciding if the persistence of low blood sugar was a result of poisoning. You really cannot make this stuff up. I've said it before, but the world must really be laughing in ridicule at the UK over this regression to some combination of the medieval witch hunt and like druid Wicker Man culture. The judge's last two sentences on Child F, apart from one representing the obligatory hit on Facebook searches on the parents, was as follows, I quote, "She confirmed she did not know about C-peptide at that time. She knew adding insulin was life-threatening to a child like Child F," end quote. Goss just embarrasses himself here. This is the kind of edit the old school detective who left school at 16 with 5 O-levels routinely presented to courts up and down the country to fit up the suspect. In the stupid clever mind of the author, there is an apparent to them subtle reading between the lines subtext being conveyed here that this position by the defendant amounts to an admission of guilt. Miss Letby obviously knew that the method of attack she is accused of employing was suitable for that purpose, but at the time was unaware of the chemical smoking gun associated with using it, and it was that lack of awareness which enabled the murder attempt to be detected. The jurors all need to be ashamed of themselves for rolling over on so crudely amateurish an insult to the intelligence, even if they did hold out for the best part of 3 weeks before capitulating. The afternoon of July 4th is closed out with the summing up on child G. The content reviewed for jurors is largely the preposterous medical claims of Evans, based primarily on his own inner psychological needs and constraints, and the desperate efforts of Bohin to support them while retaining professional credibility. You have heard all of it before, and even the pro-guilters out there now know it all to be nonsense, though they seem to lack the emotional maturity or character to say so. The only point worth noting about the summing up is the extraordinary fact that in the very same passage of speech, the judge gives information that the reason for the child's transfer to Level 3 Arrowe Park Hospital was presumed sepsis, and information that the prosecution's primary expert's evidence was that the child's health collapses were a result of being given too much milk. As explained in the previous video, sepsis is profoundly life-threatening in anyone, let alone an extremely premature neonate already with the respiratory distress syndrome, which is the hallmark and most dangerous feature of prematurity. It is also mentioned that Evans even gave evidence that this was, child G, was the very first case he reviewed. To the extent we feel we can take anything that man says at face value, it is the best evidence that such expertise in diagnosis that he may have once possessed was long gone by the time he came to review the collapses at the Countess. Moving on to Wednesday, July 5th, the judge begins with child H. This is one of the cases that set me wondering about the possibility of an agent pre-planted among the jurors by less than random selection, or secretly recruited after summons to surreptitiously manage and guide discussions towards conviction. Even in the state of information poverty the jurors were cynically reduced to, the suboptimal care conceded by the prosecution made this baby a banker for the reasonable doubt necessary for a blanket finding of not guilty, especially as the prosecution didn't offer an attack method. Yet, while one of the two counts results in the predictable not guilty, in what appears to me to be identical circumstances, in the second count, these people en masse vote the opposite way. Very strange. This is how the judge summarizes the evidence against Miss Letby. I quote, "The prosecution say, acknowledging the suboptimal care and challenges child H faced, the coincidences of the collapses when Letby was present and being involved in child H's care, the unexplained collapses, and Letby's interest in the family and other events, that she was responsible by whatever method for the collapses by deliberate harm on 2 occasions." End quote. This child needed to have a tube inserted into its chest on 3 occasions. Seeking a conviction in these circumstances is just about the definition of a reach. Nevertheless, they actually got one. He addresses the chest drains in his summing up, but only partially. He reminds the jury of Jayaram's Scout's Honor assertion that leaving the tip of the instrument in a position which risks the catastrophic consequence of its shifting and touching the heart was not a big issue, but does not remind them of the following. 1. That Jayaram placed the draining instrument between the wrong pair of intercostal ribs. 2. That Jayaram admitted on the cross-examination to lying on the contemporaneous record that he'd put it between the correct intercostals. And 3, the Keystone Cops farce of him having only used a straight drain instead of the more appropriate pigtail one because there were none left, and the need for his botched effort to be swapped out by a new drain fetched from the children's ward. The judge's reason for not including this stuff may have something to do with how that knowledge for the jurors, in the context of Miss Letby having them knowing that Miss Letby had submitted a Datix report on the consultant's botched effort, might have influenced jury thinking on just whose credibility they should be questioning. As stated, the prosecution didn't even bother to cite an attack method for child age. That didn't prove too much of a problem, though, as the prosecution team found itself in the fortuitous position of having a judge willing to insinuate one on its behalf. I quote, "She denied sabotaging the chest drains and said they were not stitched in place." End quote. Note that this is a more serious instance of the synthesizing of evidence I drew attention to in the Child E summing up assertion of significant conflicts between the evidence of Miss Letby and the parents. Think about it. There is no allegation that Miss Letby tampered with the chest drains. Their relevance to the counts is purely A, whether or not the explanation for the cardiac arrests is that Jayaram's chest drain may have touched the heart, hence the main thrust of his and his colleague Gibbs's testimony being the disparaging of that obviously very real physical possibility, and B, the more general question of the physical stress of undergoing 3 such procedures being something that could trigger collapses. As I said, this is a case where no attack method is actually cited. In making this utterance to the jurors, Goss creates an attack method out of thin air. This is so because of the way the human mind works. Or rather, this is so because the way the human mind works, to introduce the idea of the denial of sabotage by Miss Letby into a mind is to automatically introduce the opposite idea of her being concerned in the sabotage denied into the self-same mind at the same time. If you doubt what is admittedly a challenging concept, speak to any police officer you know, or the next one you happen to be in a position to have a conversation with, and ask them to say what their experience has been on those occasions when, off duty in a restaurant or venue, they've taken the trouble to point out to the owner of a handbag placed on the floor outside of their peripheral vision, especially adjacent to a walkway, when they've pointed out that bag is in danger of being stolen. My experience is just about every one of them will tell you that they are rewarded with a frown of suspicion, as if they were the threat to the person's property, not the smile and thanks that rationality would suggest would be the final part of such an exchange. In addition to being the synthesizing described, that piece of disinformation is also another instance of the same reading between the lines malicious speculation subtext play previously described, where the stupid are baited into feeling clever by apparently working out all by themselves that Miss Letby likely did the insulin poisoning on the basis that they can see she knew insulin could kill, but didn't know that using it to kill would, or try to kill, would leave the chemical smoking gun. I'll repeat the quote. She denied sabotaging the chest drains and said they were not stitched in place. The big clue and giveaway that this is the reading between the lines thing is that second clause, they were not stitched in place. To present the information that way is to invite malicious speculation along the lines of, there you go. Because they weren't stitched in place, she was able to manipulate them. Or, how did she know they weren't stitched in place if she didn't mess with them? Basically, Goss, in saying this in his summing up, is putting it out there that while the prosecution cannot find a suitable attack method, or the collapses do not readily fit their stable of attack methods, Miss Letby may have, on this particular occasion, or that particular occasion, chosen to attack by manipulating the chest drain tube. Typically, as has been the case from the very beginning, the forces of darkness are seeking to have it both ways. If Miss Letby is not associated with the chest drains in jurors' minds, then they had absolutely nothing to do with the collapses. But if she is associated with the drains, they then suddenly become a possible method by which she attacked this particular baby. Then, in telling the jurors that Miss Letby denied deliberate harm, he also tells them that she was unable to explain the collapses. Why is it necessary to mention in his summing up that when it was put to her she had no explanation for the collapses? Some 50% of neonate deaths apparently remain unexplained even after a post-mortem, and she's only a nurse. You really have to start asking yourself just how much evidence the more alert among the jurors needed to work out they were being led by the nose, and with no great subtlety at that. The question why would follow naturally, and from there it would be the shortest of mental steps for social intelligence to tell that juror that the safest answer to the all-important question in front of them once in the jury room was the opposite one to that they were being so actively encouraged to embrace. In a previous video, I praised them for holding out for almost 3 weeks. If I'd known they'd had so many clues that something truly ugly was afoot, that even a disoriented crackhead would have been able to work out that something stank, I wouldn't have been so generous. My sense now is that these people just threw the towel in order to just get out of an admittedly oppressive situation, leaving a person many would have been almost certain was not guilty to shift for herself. That's the real reason they were crying. These are strong words, but there is always a choice. What that jury needed was a couple of practicing Christians. People kept honest by the fear of eternal damnation for their immortal souls. Or perhaps just one honourable person. I'll pick things up with a child eye summing up next time. Feel free to share your thoughts in the comments section below. As usual, thank you for watching, thank you for your time, and all the best.